Let me repeat your situation first because I want you to know that I have understood your question properly. You are saying that a child was born here in England. The child's father is British. The father already has a wife and children from his first wife. The child's mother is Pakistani. That's you. She came to UK on some other visa. And now the question is, can the mother get British nationality or the right to stay in the UK because her child was born here and the child's father is British? So this is not just a legal question. This is a mother's question. Behind this question, there is usually fear, uncertainty, and worry. A mother is thinking, my child is British, my child is here, my child needs me. What will happen to me? Will I be separated from my child? Can I stay lawfully? Can I build a safe future for my child in this country? So let me explain this gently but clearly. The first point is about the child. If the child was born in England and at the time of the child's birth, the father was British, then in many cases, the child will be British automatically under Section 1, subsection 1 of the British Nationality Act 1981. But this depends on the evidence. You must be able to prove the father's British citizenship and the father's legal relationship to the child. Usually, this means the child's birth certificate, the father's British passport, or certificate of naturalization, and any other evidence required to prove paternity. But now let us come to the mother, you. And this is where many people make a mistake. The mother does not become British automatically just because her child is British. UK law does not say that if your child is British, you automatically become British as well. So the mother should not think my child is British, therefore I can apply straight away for British nationality. That is wrong. For the mother, the correct route is normally immigration first, nationality later. In other words, first, she may need to apply for permission to stay in the UK. Then, after some years, she may apply for indefinite leave to remain. And only after indefinite leave to remain, if she meets the requirement, she can normally think about British citizenship. So the real question is not, can the mother get nationality immediately? The real question is, can the mother apply for leave to remain in the UK as the parent of a British child? In many cases, the answer may be yes, but it depends on the facts. The mother may be able to apply under Appendix FM of the immigration rules as the parent of a British child, but she will need to show that the child is British, the child is living in the UK, and she has a real parental role. For example, does the child live with her? Does she have parental responsibility? Does she take the child to school? Does she take the child to the GP? Does she feed the child, care for the child, comfort the child, and make day-to-day decisions for the child? All this is highly relevant because in these cases, the Home Office does not just look at the birth certificate, they look at the reality of family life. They ask who is actually caring for this child, who is emotionally and practically responsible for this child. Would it be reasonable to expect the British child to leave the United Kingdom? And this is where the law gives some protection. Under Section 55 of the Border, Citizenship and Immigration Act 2009, the Home Office must consider the best interest of the child. Under Section 117B, subsection 6 of the Nationality, Immigration and Asylum Act 2002, where there is a genuine and subsisting parental relationship with a qualifying child, including a British child, the law asks whether it would be reasonable to expect the child to leave the United Kingdom. And the Supreme Court case of ZH Tanzania makes it clear that the best interest of a British child must be treated as primary consideration. Now, this does not mean every application will automatically succeed. It does not mean the Home Office will simply say yes because the child is British. But it does mean the child uh, case must be considered carefully, lawfully, and with proper regard to the child's welfare. Now, let me talk about the most sensitive part of your question. You said the father is British, but he already has a wife and children from his first wife, and the child's mother is the second wife. This is very important. If the father is still legally married to his first wife, then the mother may have difficulty applying as his spouse under UK immigration law. A second marriage or polygamous marriage situation can create a serious problem. So it may be safe to say apply as a wife. It may not be safe to say apply as a wife. That may be the wrong route. In some cases, the safer and more realistic route may be to apply as a parent of a British child, not as a spouse. But again, this depends on the evidence and the immigration history. Let me give you a few examples. If the mother is still in the UK on a valid visa, then she may be able to switch to a family route before her visa expires. That is why timing is very significant. Do not wait until the visa has expired. Do not assume that because the child is British, everything will be fine automatically. It is always safer to take advice before the visa expires. Now, if the mother is here as a visitor, the position is more difficult. A visitor normally cannot switch into a parent route from inside the UK unless there are exceptional circumstances. So again, the strategy has to be considered carefully. And if the mother has overstayed, then yes, the case becomes more difficult. But difficult does not always mean impossible. If the child is British, if the mother is the main carer, if the child depends on her emotionally and practically, and if it would not be reasonable for that British child to leave the United Kingdom, then there may still be an argument under Appendix FM and Article 8 family life. But the evidence must be strong. You cannot just say my child is British. You must show the whole picture. You must show the child's life in the UK. You must show the mother's caring role in the child's life. You must show why separation would be uh, harmful for the child. You must show why it would not be reasonable for this child to have uh, to leave the United Kingdom. So my advice to you is this. First, confirm the child's British citizenship. Second, gather the child's full birth certificate. Third, gather proof that the father was British at the time of the birth. Fourth, gather evidence that the child lives in the United Kingdom. Fifth, gather evidence of mother's day-to-day care. School letters, GP letters, nursery, photographs, household bills, letters from professionals, and any sort of evidence showing that the mother is the person caring for the child. And sixth, before making any application, get proper legal advice on the correct route, because the wrong application can cause serious damages. It can waste home office fee. It can create a refusal history, and it can make the next application more difficult. So please remember the key point. A British child does not automatically make the mother British, but a British child may give the mother a possible route to stay in the UK lawfully as a parent. The route must be prepared carefully with the right law, the right evidence, and the right explanation. Likewise, at Kayani Legal, we look at these cases with both legal precision and a human understanding. Because we know that immigration law is not just about forms and documents. It is about families. It is about children. It is about mother laying awake at night, worried about whether she will be separated from her child. And it is about making sure that the Home Office sees the full reality of that child's life. Subscribe and share. See you soon.